when this has become a huge business. Billions of dollars are raised through leveraged leases. Another case comes up. Unfortunately, the names are backwards. Worthen Bank is not the bank, it's the user. Frank Lyon Corporation is not the user, it's the bank. But the facts are the same. Worthen builds a building with construction financing, sells it to Frank Lyon, leases it back from Frank Lyon. It's exactly the same transaction. But when it comes through the courts, well, before I say that, the IRS looks at this. Now they say, we learned our lesson in Lazarus. So we're going to go against Frank Lyon. Now you may say, why didn't they go against both? That's easier said than done because the taxpayer gets to choose where things get litigated. But in fact, they went against Frank Lyon. They said, we read Lazarus, you're not the owner, you're a mere lender. You don't get all the benefits of ownership that you claimed on your return. Their only interest, they were a profitable company whose only interest was getting tax losses. It goes all the way up to the Supreme Court. The Supreme Court is not particularly lucid. They don't mention Lazarus. Mike, I know you're upset about that. They just don't even mention it. They don't say whether they think it's good, bad, or indifferent. They just don't mention it. They look at all the facts and say all the facts, everything that the people have said is true. There was independent evidence that the building really was worth $7.6 million, which is the value at which the transaction was done. And then they say, and there's a third party involved here, New York Life, because Frank Lyon didn't hold on to the note. It bought the building with a note, but it then sold that note to New York Life. And at the end, looking at all of this, not mentioning Lazarus, smoke and clouds, the Supreme Court enunciates that this is a true business transaction imbued with independent non-tax considerations and involving multiple parties, meaning apparently 3 parties rather than 2. Again, the Supreme Court is blessing this transaction, saying that Worthen really sold the building to Frank Lyon for cash and a note. Frank Lyon really leased it back. New York Life buys the mortgage, gets the rental payments. It's the classic leveraged lease transaction, but to the great relief of Wall Street, it was blessed by the United States Supreme Court. At this point, 40 years, 50 years later, it's hard to see anything else. Leveraged leasing is such a huge part of the economy, but it could have gone the other way. And when you go back and reread it, understanding why it went this way is incomprehensible. It was the Supreme Court just simply deciding it wanted to go this way and making up a form of words. And technically, Lazarus is still on the books. So if you have to give anyone an opinion, you have to say, well, there's Lazarus and there's Frank Lyon, and where are you on the spectrum between the two?